Hello everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today I am going to discuss about privity of contract. The doctrine of privity of contract is a since a long time ago settled rule of English law which gives that nobody might be qualified for or limited by the provisions of the agreement, to which he is certainly not a unique gathering. As such, it is a customary law guideline which specifies the rights or commitments must be forced on gatherings to an agreement. The tenant keeps an outsider from having any lawful option to implement the agreement or to have legally binding liabilities forced because of the agreement, and that authoritative cures are for the contracting parties alone. Basically, it keeps an outsider from implementing the conditions of an agreement. Consequently, the principle has demonstrated to be hazardous for outsiders as they are not in a situation to implement commitments of the contracting parties. It is to be noticed that the Indian Contract Act 1872 doesn't contain a solitary agreement identifying with this doctrine. It has been broadly acknowledged in India through a progression of case laws. Area 2H of the Act 1872 characterizes an agreement similar to an arrangement between two gatherings enforceable by law sponsored by same thought. All in all, contract is only a substantial agreement. The term agreement has been characterized under section 2A of the Act. As per this part, every guarantee and each set of guarantees shaping the thought for one another is an understanding. Segment 2D characterizes thought as a demonstration that probably been done at the craving or solicitation of the promiser. One of the prominent highlights of this segment is that the demonstration, which is to comprise a thought, might be furnished by the promisee or some other individual. This implies that as long as there is thought for the guarantee, it is unimportant who has outfitted it. So what is the meaning of this? The privity of contract doctrine is a sincere, quite a while ago settled English law idea that ensures that nobody ought to be qualified for or limited by the agreements of the game plan to which he is anything but a unique gathering. At the end of the day, it is hypothesis of precedent-based law that gives that advantages or obligations ought to be upheld just on the parties to a contract. The convention makes it hard for an outsider to have any authentic ability to execute the contract or to have contractual liabilities authorized because of the contract, and that contractual alternatives are only for the contracting parties. Fundamentally, it restricts the outsider from forcing a contract's terms. The hypothesis has likewise ended up being inconvenient for outsiders since they are not in a situation to carry out the contracting parties' commitments. What are the legal provisions related to this? Legal doctrine that an agreement gives rights and force liabilities just on its contracting parties. They and no outsider can sue one another under the conditions of the agreements. Privity is the legal term for a nearby, shared or progressive relationship to a similar right of property or the ability to implement a guarantee or guarantee. The doctrine of privity in agreement law gives that an agreement can present rights of force commitments emerging under it, and any individual or a specialist with the exception of the parties to it. The doctrine of privity of contract implies that alone those associated with making a deal would have remaining to uphold it. Overall, this is as yet the situation. Just parties to a contract may sue for the penetrate of a contract, albeit as of late the standard of privity holds dissolved fairly, and third gathering recipients have been permitted to recuperate harms for the breaks of contracts they were not gathering to. There are multiple times where outsider recipients are permitted to fall under the contract. The obligation owned to test hopes to check whether the outsider was consenting to pay an obligation for the first party. The expectation to profit test hopes to check whether conditions demonstrate that the promisee means to give the recipient the advantage of the guaranteed execution. There are some exceptions to the rule of privity. Number one, trust. Trust is a ground exemption for the standard of privity. This implies that if A makes a guarantee to B to help C, C can uphold this guarantee if B has comprised himself trustee of A's guarantee for C. However, this standard is dependent upon specific limitations. A promisee can be held to be a trustee for an outsider just in the event that he has the goal to make a trust, and this aim should be to profit the specific outsider and not outsiders for the most part. Number two, covenants concerning land. The law permits certain agreements, regardless of whether positive or prohibitive, to run with land to profit or wait individuals other than the first contracting parties. The important contract may identify with freehold land or leasehold land. The law on agreements identifying with leasehold land has of late been improved by the Landlord and Tenant Act 1995. Number three, agency. Office is the relationship which exists between two people, one of whom the head explicitly or impliedly assents that the other should follow up for his benefit, and the other of whom comparatively agrees so to act or so acts under this. The head, for example the outsider, might be profited or troubled. The presence of the chief doesn't host to be known to the gathering with whom the specialist is contracting. Additionally, a specialist might be the specialist of both the contracting parties. Accordingly, protection merchants are the two specialists of the safeguarded and of the backup plan. In conclusion, I'd like to say that with the help of fundamental administrative activities and choices in different nations, particularly those of England and India, this investigation has set up the premise of the doctrine of privity. The current unperturbed requirements of present-day contract law and the non-customary approach of the legal executive proportionate to doctrine of privity have given a way to review the authentically influenced people who subject to the exacting explanation of doctrine of privity might have been denied of rights essentially. Under the current strategy of the law, an outsider could be granted harms if the negation is demonstrated. Nonetheless, the outsider ought to be included until the degree of the proposed recipient who has corresponding commitments. Appropriately, it was attractive and normal that the individual who is an alien to a contract ought to be forced with contractual liabilities and furthermore get contractual advantages. With a view to helping such people, the courts in the long run perceive certain social cases for the privity rule. These special cases make it mediocre, particularly speaking. Yet the inquiry emerges whether it would be smarter to additionally change the convention or to cancel it completely. With the expanding disagreeability of the principle, the legal executive built up various ways around it. These were frequently both mind-boggling and fake, and utilized the law identifying with offices and trusts alongside different thoughts and regions like guarantee contracts. These special cases, however, have been restricted in how they can be utilized. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe the channel LEXCLIQ.